So first of all, I'd like to introduce Professor Jonathan Boston, who will chair tonight's session. And Jonathan is the head of the recently regenerated Institute of Governance and Political Studies at the university, which also is inciting considerable debate. So thank you, Jonathan. Welcome, and the floor is yours.
Well, kia ora. It's a great pleasure to be here, and thank you for your welcome, Mike. The State Sector Act was a landmark piece of legislation. It fundamentally changed New Zealand's system of public management. And along with its companion acts, most notably the State-Owned Enterprises Act, the Public Finance Act and the Crown Entities Act, it provides the foundations of our contemporary system of public administration. The State Sector Act was the product of various forces, pressures and ideas, not least concerns that grew during the 1970s and 80s over New Zealand's relatively centralised, top-down and bureaucratic system of public administration, and the perceived negative impact of this on efficiency, effectiveness and accountability. The aim of the State Sector Act, as I'm sure most of you are well aware, was in short to sort of free up and improve the system of public management by devolving core management responsibilities to departmental chief executives and put in place a new regime for appointing those departmental chief executives and then holding them to account. The design of the State Sector Act reflected the influence of various philosophical and theoretical schools of thought, including managerialism, the new economics of institutions, and market liberalism, obviously a product particularly of the influence of the Treasury during that period. At the same time, the Act was designed to retain a meritocratic public service dedicated to the non-partisan and professional provision of advice and the delivery of services. There can be little doubt that the Act has had both positive and negative consequences, as do all major reforms. Today provides an opportunity to reflect on the lessons from this remarkable legislative initiative. And it's really fantastic in my view that we have today in our midst really the two key pivotal players in the design and initial implementation of that Act, Stan Rodger and Sir Geoffrey Palmer. And let me just briefly introduce the two speakers and then I'll hand over the cudgels. So Stan Rodger had a distinguished career in public service, including being president of the PSA in the early 1970s. Subsequently, he became the MP for Dunedin North, a seat he held from 1978 to 1990. During the fourth Labour government, he was, amongst other things, Minister of Labour, Minister of State Services and Deputy Minister of Finance, and was a key architect of the State Sector Act, as I mentioned. Subsequently, he has worked in academic administration and has served as a director, amongst other things, of New Zealand Post and the Electricity Commission. So welcome, Stan. And Sir Geoffrey Palmer, I'm sure as everyone knows, is one of our leading constitutional lawyers, an academic, parliamentarian and author, and until quite recently President of the Law Commission. During the relevant period of the fourth Labour government, he was Deputy Prime Minister and then subsequently Prime Minister. He was Minister of Justice, Minister for the Environment, and no doubt many other things. I think sometimes, Geoffrey, people thought you were Minister of just about everything. He has written extensively on constitutional matters, obviously, in public administration, and is currently completing his memoirs, which will be published in November. He tells me they're a mere 330,000 words, so it will be a good summer read. All right, so welcome to you both. Stan, we're in your hands.
Mike Smith, Professor Jonathan Boston, Right Honourable Sir Geoffrey Palmer, the Honourable Trevor Mallard, who knows probably more about the content of this bill than I do, because he sat in the Select Committee working on it when it passed through the Parliament, Mr Kevin Haig MP, ladies and gentlemen, members of the PSA, fellow members of the PSA. I welcome this opportunity for the first time in 25 years to give a public speech on the State Sector Act. Nobody has invited me to do so prior to tonight. After the 1984 snap election, and once I knew I was to be a Cabinet Minister, I indicated to the Prime Minister-designate, David Lange, that I sought to be Minister of Labour, and if so favoured, would also wish to be Minister of State Services. I made this request as, amongst other things, I had a personal desire to harmonise the private and public sector industrial regimes. I received my warrants for both portfolios on the 26th of July 1984. My first task was to preside over negotiations to end the long-running wage freeze imposed by Robert Muldoon. With a ton of goodwill from both unions and employers, arrangements were made to break out of the freeze. Legislation was quickly enacted, enabling awards to be renegotiated from the anniversary point of when they had been frozen for 38 months. We knew it as the 38-month rule. The legislation also contained provision to remove the long-standing practice of enforcing, via decisions of the court, fixed relativities between occupational groups. Relativities between all groups of industrial workers were frozen, or had been for decades, and had endured over long periods of time. Henceforth, account had to be taken of factors such as supply and demand for skills of workers, changes in job content or responsibility, and changes in productivity. As a result, the subsequent wage movements of discrete groups has been possible where that has been warranted within the broader community. Once arrangements for the ending of the freeze had been completed, I turned my attention to the new private sector regime. I decided to do so by way of a comprehensive green paper which was issued on the 17th of December 1985. That's only the question part of it. It was a big volume that went with it that had an explanation of the elements that existed within the private sector employment arrangements. And the history of the Employers' Federation, the officials said it was the first time the Employers' Federation ever actually had a history written. And of course, the Federation of Labour was described and the industrial arrangements that prevailed up until the freeze. So once that had been issued and we'd had all the feedback from it, the Labour Relations Act came into effect on the 1st of August 1987. I can now confide that throughout this lengthy process I felt politically vulnerable. I have always held the view that the labour market is different from other markets. Going to work bears little resemblance to going to the corner store to purchase a can of baked beans. It seemed to me that only a few in the Cabinet shared this view. I was subject to considerable pressure from the Round Table, the Treasury and the Finance Ministers to open up the labour market and to significantly dilute union and worker rights. They greatly disliked the provisions of the Act, and until the Act was finally passed, I was concerned that attempts would be made to add new and damaging carriages to the legislative train. In the event, those interests got their way in 1991 with the passage of the Contract Employment Act. With the private sector regime well in hand, I turned my attention to the public sector. The issues to be addressed were substantial. Accountabilities were weak. The wage fixing system was hugely detailed, based largely on relativities. No one seemed to be responsible for anything. If you were a permanent head and you blew your budget, you might be rebuked by the minister, but essentially the Treasury and the government had to cough up. If you needed more staff, you went to Cabinet, and if the SSC, State Service Commission and Treasury agreed, you would, after considerable delays, probably get them. If you wished to pay more to a particular good employee, you had to submit a case to the State Services Commission. Staff salary levels were decided in an SSC PSA negotiation in which you had no involvement, The impact on your budget had to be resolved subsequently in departmental treasury discussions. If you needed more office space, you were beholden to the Government Office Accommodation Board, a subset of the State Services Commission. If you needed motor vehicles, then you went to the Motor Vehicles Committee, which was run by the Transport Department. If your own salary was determined by the Higher Salaries Commission, quite without regard to your personal performance and qualities. The extracting of efficiency gains from the public service proved elusive for a succession of governments. So, over time, governments had resorted to a variety of different methods to contain expenditure, some of which will be known to and you'll recall. Staff ceilings, sinking lids. That was the staff ceiling, but it just kept going down. You've got it now, as I understand it. Prime Minister Muldoon's contribution from his quite small department was to sack his tea lady. He didn't drink tea anyway, so I didn't suppose it mattered, but the others in the office probably did. There were 3% across the board cuts, and the National Party for a time ran a system of tit for tat. You could get a new policy if you abandoned an old one, so as to keep expenditures neutral. All of these attempts at control were prudent and effective. I decided early in 1986 to embark on a different approach to attempting to get change in the public sector arrangements for pay settling. Mindful that in 1945-46, a public service consultative committee comprising 8 members, 4 from the Public Service Association and 4 from the Public Service Commission, set the basis for the structure and pay rates for the entire public service following the distortions following from the years of war. I decided that such a technique should be given another life, because this report stood the public service in pretty good stead for 40 years. So I thought, let's have another go. And so, with Cabinet approval, I sense somewhat reluctantly given. Treasury was opposed to it. State Services Commission couldn't say anything because I was the minister. But I had a feeling that there were people who thought that this was a bit adventurous and probably ought not to be tried. But with Cabinet approval, I offered the combined state unions the opportunity to work with the State Services Commission and Treasury to come to a consensus on future arrangements. The combined state unions agreed to participate. The membership of the committee was Mrs. M. Baisley, now Dame Margaret, Mr. David Swallow, long since retired but recently gone on to the Executive of Age Concern New Zealand, lives up the coast, Mr. Jazz McKenzie, who's the representative from Treasury and subsequently became Secretary for Labour, Mr. Colin Hicks, the late Mr. Colin Hicks, Mr. Ron Burgess, and Mr. Barry Tucker, the late Barry, and Barry was replaced by Colin Clark, the General Secretary of the PSA, on Barry's retirement. My rationale for using this approach was that the resulting legislative changes would be owned by the participants. As state pay fixing was fiendishly complex and understood by almost no one in the Parliament, any agreed legislative package would have flown through. Just imagine trying to, in a caucus, argue against Treasury, State Services Commission and the state unions. It just wouldn't have. It would be hard to mount an argument. After many constructive sessions, the consultative committee flew apart. I was told subsequently that the PPTA refused to concede change within the combined state unions. And so, from a state union perspective, a golden opportunity was lost. The State Sector Act would have been much different if it had been the product of the deliberations of that consultative body. From my perspective, consultation had been tried and had largely failed. With the loss of so much time, the process now had to be accelerated in a conventional way. On the 1st of October 1986, a government paper known as the Buff Paper was issued. It was a young reporter who was attached to the National Business Review office, parliamentary office, who received this in his inwards tray, and he was write up an article about it, and he came round to my press secretary and said, "Well, I've got a question for you." She said, "Yes, what is it?" What are the initials of Mr. Buff? The report was issued entitled Pay Fixing in the State Sector, and responses were invited by the 1st of November 1986. Various exchanges occurred subsequently between the CSU and the government, but they were inconclusive. Late in October 1987, I convened an ad hoc committee comprising Geoffrey Palmer, Richard Prebble and myself. We received a paper prepared jointly by the State Services Commission, and I'm almost certain that it was Doug Martin that had prepared that for them, and the Treasury, and I'm equally almost certain that it was done by Alf Kirk. And at that meeting, much discussion revolved around that paper, but more especially on the basis of appointing chief executives. Finally, we settled on the procedure recommended in the 1962 Royal Commission. The report was the responsibility of Sir Thaddeus McCarthy, who actually did 3 Royal Commissions on public service issues. And we went back and found this process, and we thought, well, that's quite remarkable. We will pick that up. Everything flowed from there. 2 further meetings were convened of the ad hoc committee. Drafting instructions were issued to the Parliamentary Council. Mr. Walter Isles was the Chief Parliamentary Counsel. He was a wonderful drafter and had for many years worked on all industrial relations bills and their related regulations. As a consequence of that high quality drafting, including all the wage-free stuff that he had done for Muldoon, virtually none of that legislation was knocked over by the courts. It was of a very high order. A significant delay then occurred. He seemed unwilling to pick up his quill. This could have upset my timetable. I objected to Geoffrey Palmer, who was responsible, amongst all those things he was responsible for in the government I was a member, and he rang Walter a few times and chased him along. But there didn't seem to be a great deal of rapidity because nothing emerged. And I was anxious to get the bill into Parliament before the end of the legislative session. I wished the time for the receipt of the submissions to run over late 1987 and early 1988, as the PPTA, who had taken such a negative view on the possibility of legislative change, would not go on strike while they were on vacation. In the face of law drafting delays, the Office Solicitor of the State Services Commission, David Bradshaw, volunteered to do the drafting. And so on the 10th of December, the bill was introduced to Parliament. It was pretty rough around the edges. I don't think there was much of it that survived the Select Committee process and the subsequently supplementary order papers that kept being fed up into the Parliament as it was going through to modify most of the content within it. I see Trevor Mallard nodding because he was there at the sharp end of the Select Committee. At that point, the CSU and PSA made, in my view, a major tactical error. And I'm sorry to be critical of you when you're the sponsors of tonight, but I owe it to you to be frank as I said. Their response was to mount a campaign to kill the bill. You might have even seen some posters and material around, kill the bill. They did not, it seemed to me, adopt any other tactic. In spite of informal and formal approaches from me seeking advice as to what changes they might wish to see made in the bill, no response was forthcoming. I invited Barry Tucker and Dr. Probine, both. Barry was a retired General Secretary of PSA. Dr. Probine was a retired Chair of the State Services Commission, to call on the state unions and ask them for a shopping list, if you like, of changes they might wish to see in the bill. They came back and said they had been unsuccessful. Ken Douglas is in the front row. Ken was somewhat troubled by the approach that was being taken in respect to the bill, and he intervened from the Council of Trade Unions. And it was agreed that there would be a meeting prior to the report back of the bill, at which I said, you don't have to have one list. If you've got pressures within the combined state unions, and you can come up with different lists, and we'll see what we can make of them for change. Final farce really occurred on the 10th of March 1988 when a CTU brokered meeting at which the combined state unions and the ministers were scheduled to receive lists of suggested changes to the bill. The combined state union representatives did not appear, although the CTU did attend. And so the bill proceeded through Parliament and took effect from the 1st of April 1988. Henceforth, the public and private sector's industrial regimes were harmonised. Chief executives of departments became the employers of their staff and were responsible for all aspects of their employment conditions. The provision that existed since 1912 that matters relating to decisions on individual employees, whether matters relating to appointment, promotion, demotion, transfer, disciplining or cessation of employment, were to be made independently of ministers. Chief executives were no longer permanent heads, but fixed-term employees for 5 years, with an ability for extensions of term. No longer were these top appointments the preserve of those at the twilight of their careers. No longer were they predominantly male. Together with the provisions of the later enacted Public Finance Act, CEOs could be held genuinely to account for the functions they were responsible for. How has the State Sector Act performed? I believe the Act has performed pretty well over the past quarter century. Few modifications have been made to its provisions. The provision for the creation of a senior executive service, for which I obtained funding, and I emphasise the significance of that, I got the money from the Finance Minister to set up the senior executive service, intended to function on common issues as between departments. And I don't know whether that section is still in the Act. There's people shaking their heads. It's gone. Well, anyway, it was a good idea, I thought, and I got the money for it. But the chief executives basically were reluctant to release high-quality officers for this level of activity. Another failing, I believe, has been an emphasis on silo activities rather than interdepartmental activity. Such impediments can, of course, be fixed by ministers giving clear directions on clearing such impediments. The current government solution to silos seems to be to bring about mergers. The benefits of such activity is very debatable. The disturbance to set public service arrangements is both unsettling and inefficient. Anyone having to deal with the giant Ministry of Business, Innovation and Employment will be aware that whilst its activities have not become paralysed, they are certainly sclerotic. Sadly, I don't think the Ministry will survive in its new configuration. Political change will alter its shape. For the future. New challenges to society, new views on what is appropriate will no doubt bring further legislative change to modify or replace the State Sector Act. So be it. I am not here to defend every element of the State Sector Act. I think it was appropriate for the time. I think it served public sector well. But I'm not one of those that says we are not to have ongoing change. And I welcome this forum as one of those which will tease through some of the possible changes for the future. I understand that questions are going to be at the end after the presentations, so thank you very much for your attention.
Kia ora, ladies and gentlemen, and may I pay a compliment to my erstwhile ministerial colleague Stan Rodger, who was a wonderful minister. In many ways, I just want to tell one story about Stan Rodger and the State Sector Act. At Cabinet, I used to act as the sort of person who thought that open government was a good idea. And when we got to the Cabinet to consider the introduction of the State Sector Bill, I suggested we should consult with the state unions about it. And Stan said, you can consult or you can have the bill, but you can't do both. And that was the end of that argument. And indeed, that was quite correct, given the history that he has recounted here tonight. I think it's important to begin what I have to say with this observation. that passing an Act of Parliament does not actually in it of itself improve public administration. And you can't actually manage people via an Act of Parliament. And the limitation upon legislation to produce outcomes needs firmly to be borne in mind when one is talking about the New Zealand Public Service, I think. And I do want to recall what Stan said about the Labour Relations Act. We did labour very heavily in the caucus committee that went on and on and on forever, because it did seem to us that the policies that had removed union protection by the so-called voluntary unionism at that time were not good, and that the unqualified preference clause had a lot to be said for it. And we did introduce an act that, of course, didn't survive the 1990s, but which did protect unions in a way that I thought was necessary. They were in my electorate in Christchurch, and I got to understand the problems that people have advocating for union members. Now, the background that I want to give to the State Sector Act is somewhat different from Stan's, because I was never a person who understood much about the Byzantine wage negotiations that occurred, and I don't now. But as a young solicitor in this town, I did a great many public service appeals, which had a special tribunal set up under the State Services Act 1962, which in section 28 defined merit and produced a jurisprudence that was of exceeding attraction to me. And I must have done 30 or 40 public service appeals in a period of a couple of years. And I tried to argue before the tribunal that this was actually a very troubled jurisprudence, that you really couldn't litigate issues about human relations of this sort. I mean, the personnel policies of the public service really ended up being litigated, and I didn't think that was a good idea. It was very bureaucratic. I remember representing a whole series of forest rangers, and it's very difficult to determine one forest ranger's performance as opposed to another. Forest rangers, as far as I could tell, tended to be rather fungible, and it was very difficult to make distinctions between them. And one of my greatest forensic successes in that regard was having a client who applied for a job in the Child Welfare Department of what was then the Ministry of Education, and they didn't consider him because he wasn't a woman. All the people in that place then were women. And I felt quite proud of that victory, but I thought that system was unsound. And indeed, there were a number of other things. The Treasury regulations, for example, required me as Minister of Justice to sign off a prison boiler. I said to the head of the Justice Department, how can I tell whether this boiler's a good boiler? I don't know anything about boilers. You get an engineer to sign it. I won't sign it. But the Treasury regulations in those days, and a whole lot of other bureaucratic impedimenta that surrounded the operation of the state services, was in fact made it very difficult for state servants to do their jobs. And it seemed to me that one of the main purposes of our operation was to remove that impedimenta so they could manage their activities more efficiently than they were able to then. Now, the truth is, as Stan said, that the chief executives, it was a sort of Buggins' turn thing. You got to the top of the department and you were probably going to be appointed, despite the fact that, of course, merit still was appealable, even in there. But I must say that what we intended to do was to make the public service more flexible. There wasn't any great ideological component to any of this that I knew about. Stan, Richard Preble and I designed this bill with a whole lot of officials interacting, and that was quite a good way to do a bill. And it was done reasonably rapidly. The drafting, as Stan says, took longer. But the career qualities of the public service, we thought, should be maintained, and the senior executive service provisions that Stan has referred to, I believe that was an essential part of the vision. And the fact that that was lost was really serious to the maintenance of a career service, because we did want to maintain an apolitical career service. The 1912 principles were tried and tested, and from a constitutional point of view, it seemed to me that they'd given us a high level of public administration that was free from corruption, something that many countries could not say. Well, now, I think, if I may change from that act to where we are now, I've got a whole different set of opinions. And those opinions have been formed from many angles in the past 20 years of practising law in this city, public law, and of being the President of the Law Commission, and having a lot to do with the public service. Now, I think the public service has declined in quality. I remember saying to Helen Clark when she became Prime Minister, I do not believe that if the reforms of the fourth Labor government were done now, that the public service has the capacity to carry them out. There are many reasons for this decline, and I want to go through what I think they are. First, I think the cult of management, which many people attribute to the State Sector Act, but which you will struggle to find any legal provisions in there about it. The cult of management has meant that we have in the public service now the idea, I think, that people who are competent managers can manage anything, whether they know anything about it or not. And I don't think that's true. It certainly isn't true in the areas I work. The legal areas, you require to have some competence before you can make judgments about them. And that is a serious lack, it seems to me, to say that anybody can manage anyone else if they're a competent manager. Partly as well, there has been a dramatic loss, I think, of institutional memory in many departments. And I find it quite staggering that I often know more about those departments than the people that I am dealing with. And that seems to me to be very sad. And I suspect it isn't restricted to legal specialties either. I think probably in the environment, which I used to be Minister of, there are some aspects of that as well. Now, the other thing is that the public service has suffered, in my view, from people migrating to the private sector because they have skills that the private sector needs and wants. And over a 20-year period, the private sector has gobbled up quite a few public servants and made good use of them, and the level of rewards that are at the top for the public servants who are left are, in my view, insufficient, and that has an effect on the quality of the staff. Now, the view that I have is that the public service needs the best and the brightest, and it has to be able to recruit them. And some of the recruitments, particularly from overseas, seem to me to have been defective in terms of knowledge of the New Zealand political culture, with results that are entirely predictable. Now, another weakness that I see is that policy design is much more difficult than it used to be, much more difficult than it was 40 years ago, and much more difficult than it was when I was a minister more than 20 years ago. And the challenges, therefore, that public servants have to face are much more intense than they used to be. And the levels of skill and knowledge and research that are required to deal with those are much greater than they used to be. All-purpose generalists are hardly ever going to be enough in this environment. So that seems to me to be a problem, and also the public servants have to face up to greater transparency in their work. than they used to because of the Official Information Act, and that complicates their jobs as well, and so does MMP, as I will say in a little while. Fourth, the silo effect. The silo effect is that each department does its own thing and doesn't really want to cooperate with other departments in the interests of the wider government as a whole. And it's perfectly true to say that the Cabinet is the prime instrument of coordination, and that is what a Cabinet is for, and that many of the problems lie in the hands of ministers. But it is much more difficult than it used to be to get cooperation between officials, and when I first worked in the New Zealand government in 1969, writing a white paper on accident compensation, we had a thing called an IDCC, an interdepartmental committee that met regularly and got everything straight. It's much harder, it seems to me, to do that now, and it doesn't happen as much, and there's a lot more bureaucratic turf competition. That at least has been my observation when I was at the Law Commission. Now, the fifth thing I would say is that the legislative process is in drastic need of reform. The manner in which legislation is made and the way in which it is passed has profoundly changed as a result of MMP. The executive purports to be able to control it, but often can't. And the result is it takes much longer to pass legislation than it used to, and there is a monumental build-up, a logjam of legislation right now, and measures need to be taken to fix that, because if they are not, a great deal of important law change that is necessary for administrative reasons isn't undertaken. The sixth thing that I would say is that the Crown's legal risk is not adequately protected. The Crown's legal resources are balkanised all round the government. They're not in one central place as they are in Australia with the Attorney-General's Department. And one of the problems that I think is that the Crown's legal risk with Crown law coming in too late means that the Crown gets into a lot of lawsuits that could easily be avoided. I won't go into my theories about that, but they are lengthy and substantial. Now, the seventh thing that I would say is that there are serious structural issues in the New Zealand public service at present. The number and size of departments need some rational attention. I don't think that portfolios should be designed for the convenience of the government of the day. They should be designed for the effective administration of what those departments have to do. Some of them are too small and some of them are too big, and there needs to be some careful work done about structural change. I think that there are some serious problems with the existing structure. The eighth thing that I recognise is there doesn't seem to be as much training in the public service as there used to be. Why that has happened, I don't know, but I suspect it's to do with another one of the reasons that I think there isn't enough power at the centre. Now, I do think that one of the problems is with the Official Information Act, which is legislation that I've interested myself in and had quite a lot to do with, that many departments, the officers dealing with it, haven't been trained in the arcane tests that have to be applied in that area. The ninth thing is that I think the State Services Commission is a pale shadow of what it once was, and while I have no desire to return to the bureaucratic edifice that I previously described, and which Stan has also described, it does seem to me there needs to be greater capacity to get the public service marching in the same direction, and also to address quality issues which seem to me to be rather serious. The quality issues can be seen in things such as Pike River, such as leaky buildings, such as the education pay system called Nova Pay, and there are others. And I think there is a quality issue in our public administration that is quite serious. Now, I don't think the answer to any of this lies in the State Sector and Public Finance Reform Bill, which was recently reported back from the Select Committee. That bill seems to me to be a dog's breakfast, and it is so infected with principles of management speak that it is very difficult to understand. And I say that as a lawyer who reads many bills. I think for the 10th point that I want to make is that free and frank advice, which is a hallmark of the Westminster system, is in short supply in the New Zealand public service today, partly because ministers don't want it. And this started more than a decade ago. It's not new, but it's wrong. Ministers should be exposed to the views of the public servants, whether they like them or not. I have read many Treasury reports with which I profoundly disagree, and Treasury lose much more than they win. But the government has to have them, and you've got to be able to read them. And that's true of cabinet papers, all of which should have options, not just one that the minister likes. The minister needs advice, and without it, we're all in peril. So what this regrettable tendency is known in some circles of the public service as the traditional view, which is no longer fashionable. But I do want to say that my conclusion from all this is that we need a Royal Commission into the New Zealand public service. We need another one of the sort that Sir Thaddeus conducted in 1962 that can deal in an objective and open way with these issues and lay down some strong principles that can be adhered to. I think there's a sense of drift and unhappiness and low morale in the public service. Now, perhaps it's only because I deal in difficult areas, as lawyers tend to get involved in difficulties. Perhaps there are great vistas of wonderment out there that are effectively operating very well. It's just that I haven't seen them. Thank you. Thank you very much.
Well, look, thank you. We've had two wonderful contributions with some very interesting reflections on a variety of issues. So thank you very much to you both. The floor's open. We've got half an hour or so, and would welcome comments, questions, suggestions, but not speeches.
I was surprised actually by your comment that there was no great sense of ideology underpinning the State Sector Act. I thought it was pretty clear at the time and sensed that it was part of a well-constructed approach to public management at the time. And, people often cite the Treasury post-election briefing papers in 1987 as setting that out in a comprehensive way. So I'm surprised by your comments. Well, we just heard that ministers like free and frank advice, so I'm surprised by that. I'm genuinely surprised that you say that there was no great ideology involved. Would really like to hear your comments on that.
Well, there wasn't. I really don't think, in relation to the State Sector Act, that this was ideologically driven at all. You see, mythologies grow up around reformist governments, and everyone sees what happened and what happens, but it's, if you're actually in it, it's different. And I don't believe that there was any right-wing ideology in this act. Now, Stanley would know perhaps better than I do, but that was my view.
The discussion document, the Buff paper, Mr. Buff's paper, it did have some hard-edged elements to it. That was drafted by the State Services Commission. I don't know who drafted it, but Dr. Dean had arrived as chair after the collapse of the prospective dialogue with the state union. I mean, that's why I still look back with regret. I mean, what might have happened had there been a bit of give and take by those three agencies, the State Union, Treasury and State Services Commission. Now, maybe it was wishful thinking on my part that there would be enough give and take, but it would be a vastly different act, and that would hardly be managerially driven.
I've got a question, Jonathan.
Yes, Bill.
To both of you, looking back, Stan, you mentioned the fact that the role of employer was shifted to the chief executive. Given the fact that there's been a lot of arguments since then that in fact that contributed to the siloisation that has occurred throughout the public service, any rethinking now of the position that you took at the time? And to follow on from that, if there is, any suggestions about what needs to be done in the future?
At least in theory, we address the silo business by the senior executive service. And if you look at its objectives, I looked it up the other day because I wasn't sufficiently familiar as to whether the bill had been gutted, but it sounds that it had. The objective of this part of the Act is to require the Commission and the Chief Executive to provide and maintain a public service address to senior executives, having the ability to manage at the most senior level departments of public service, and by reason of their training and approach to management of public service, shall constitute a unifying force at the most senior levels of the public service, and shall comprise the senior service. That was, at least in theory, there. And as I say, I went the second step and went to the finance ministers and got money for it. Now, perhaps it was a failure on my part that I should have chased up, but the fact of the matter is, the senior executive service would have addressed a series of different sort provisions peculiar to one or a cluster of departments, and it would have probably been other ministers that, knowing of the prospective challenges of the interface, that should have been addressed at a political level. I mean, I think both Geoffrey and I have both said that a whole lot of problems that this government's addressed by way of nomination can actually be addressed by active ministers setting agendas and telling respective public service within the Parliament, this is the way it's to be done.
You want to comment, Jeff?
I think the question of how to avoid the silo effect in the future is a really important question. That's one of the 10 reasons that I think the Royal Commission, one of the issues that they need to address, because it's not an easy thing to do. The constitutional theory is apparent that a cabinet is a coordinating committee. That's what it is. And that gives, and the way that cabinet operates in New Zealand, which is a much more effective cabinet system than almost any other Westminster system, with cabinet greens coming out that almost have the force of law, that go around the departments and they have to follow them, and unlike Australian public servants, they actually follow them. Now, I mean, this is very good. But the truth of the matter is that there has been a change, and you can see it at a practical level. And how to overcome it? Perhaps it's because ministers compete with one another. That's sometimes an issue that causes this to occur. But the old system and the old public service, where they set up an IDCC and it thrashed the issues out, and people sort of had to you weren't allowed to go bleeding somewhere else about it. What came out was it. In many ways, it was better. The system worked better, I think, in 1969 when I was first exposed to it than it does now. Well, that's a terrible thing to say.
All right, we have a question at the back and then one at the front.
This is a question for Sir Geoffrey. You mentioned point 10 that free and frank advice is a thing of the past, and you also mentioned this as a trend, which, as you mentioned, the time frame over a decade covers at least 2 stripes of government. Why do you think this is?
I frankly think it's ministerial preference. I think ministers don't like arguing about things if they can avoid it. And so if the options aren't there, the arguments are fewer. And there's not a great deal of discussion in Cabinet on the whole anyway. Most of that discussion takes place at Cabinet committees where there is a tradition of bringing in the officials if there's something you want to get clarified. But my kind of instinct about it is that it is sort of insidiously developed, and it's developed as a result of ministerial preferences. And I think public servants should stand up to it.
Can I just ask a supplementary on this, Geoff? Is it not also conceivable that two aspects of the Act itself have contributed? One is the fact that departmental or permanent heads, as they were called, are now chief executives on fixed-term and short-term contracts. And the second is you don't have a strong centre, at least you don't have a strong SSC. So you don't have a kind of agent acting strongly to support free and frank advice being offered. So you've got those two factors. One, the chief executive is perhaps a little more fearful of their position if they challenge the government too strongly, too often, and a lack of a kind of a strong buffer.
Well, I think the question about chief executives has several facets or angles to it. I think it's really important to get the best person, and I don't think that it's a good idea to have them as the chief executive for 15 years. I don't think anyone who heads a large organisation in the public or private sector should be in that situation. I think that is just a necessary part of modern administration wherever it takes place. So I don't favour unlimited terms, and the changes that we made in that respect I support. Now, if these people are feel cowed by the ministers, I would be surprised, and I would be worried about it. But I can't see that you'll be able to change that to any material degree. You might think of the precedent in the Auditor General's legislation where you get an appointment for 7 years and it's not renewable. That might be one way that would produce extremely robust chief executives. But the other point that you made was
the lack of a buffer. I mean, the State Services Commission
being weak. The State
weak.
Services Commission may not be the answer. It may be the problem. The State Services Commission doesn't have the range of functions that it used to have. That's true. But they are confined to a very large extent now, it seems to me, to appointing chief executives, in which they use industrial consultants whose judgment seems to me to be defective. But apart from that, there has
They do
to
have machinery of government, Geoffrey.
Yes.
And they should be the ethical standards body.
Yes, they should.
I mean, when Colin Hicks went in there, he wrote manuals for them.
Yes.
And I can't remember whether I had a hand in that or not. I don't think I did. But I mean, I was hugely supportive when I heard that happen, because I think that that's one of the great strengths of our public service, high ethical standards.
Yes.
And the Commission has to monitor that and act as a bulwark within the broader public sector to ensure adherence to high standards.
Indeed.
Well, there is some material about this in this legislation about which I was somewhat dismissive. And the material that is there, the difficulty about it doesn't seem to be based on a coherent set of principles that one would look for in an act. It is a great mistake to rewrite legislation of this sort by big amending acts, because what you do is you lose the principles. And that's happened to many of our Acts of Parliament, and the manner in which we design Acts of Parliament is defective. So that's a story for another day.
All right, we have a question down here.
I worked for many years in the ICI group of companies, and one of the great things there was that there was a head office in Australia, and every specialist in any state or New Zealand could refer to that specialist. If they couldn't convince their boss locally that something should be done, they had another route. They had a formal dotted line to the person in head office who wasn't actually their boss, but he could report to his boss, who could get through the chain to your boss. And sure, there were places that I consulted to at different times, places like Wellington Hospital, where the administration and the professional staff at that time only met at the top level. And it seemed to me that the government set up the state-owned enterprises, it did not give the equivalent of the head office. And I've sensed a lot of frustration by people working in government who can't get their ideas through or think something is plain wrong, and they're almost forbidden from talking to anybody else in government or outside.
Well, I think it would be very interesting to see if some program could be designed, some institutional link of the sort that you're mentioning. It should be possible to do that. The other thing, though, that I do think about the public service at the moment is it's dreadfully overworked, and its staff is going down, and it must put a lot of strains on them. And they've got so many demands to meet. It's very difficult. I think also there are weaknesses in the way we design our policy, which seriously mean that people who can contribute to it are not asked to because of the way we design it in the silo.
Sure. Thank you. Yes.
A question from the sideline for Stan. We got handed this nice glossy booklet on the way in, and I was just interested in your perspective when you responded that this wasn't a political. The PSA says here that the Unified Career Service, with its shared occupational classifications and and service-wide salary scales set up by the 1912 Act, disappeared. Now, since this is your first opportunity in 25 years, Stan, good or bad result?
It depends on the outcome of the negotiations of the independent, each of the departments. A lot of people did very well out of it. Some probably did.
A lot of people?
Yeah.
You sure?
Yeah, absolutely.
Approach the numbers sometime.
There is this, from a public policy perspective, I would be concerned of recent, the last decade, about how you've got a series of related groups. The new benchmark was set for social workers from one agency, and they were ramped up right across the others. I mean, there was informal linkages, which still remain. Social welfare competed against justice and so on.
Yes.
Yeah. Are some of the problems that Sir Geoffrey identified found in your original decision to fragment the public service and give the chief executives more authority but hold them more accountable, and presumably incentivised by this? If they succeed, they get some pay at risk, as they say. And the result is that they are not encouraged to share. They're encouraged to act independently, to ensure they have the outcomes that they can control. So when you say works with somebody else, you're sort of sacrificing your accountability, as it were, to a group you can't control. So what you have done by fragmented public service, and the mergers are an answer to over-fragmentation. The education department was fragmented about 9 bits, and now it's back to about 3, I suppose. But in order to get people working together, you can't incentivise them to act independently, which is what you've done. Hence the silos, hence the lack of coordination between departments, hence a whole range of things.
Maybe, but if the shape, the model that we had enacted with the senior executive service and with guidance as to what the elements would be to be considered by components of that senior executive service were implemented, I think a lot of the silo effect would not have been as sharp as it is today. I do accept there was a silo impact on the public sector. That has happened. No doubt about it.
Yes, please.
So, I mean, part of the liberalisation through the 80s and making with the State Sector Act and giving the senior executive service, the chief executives, that freedom and that move from a central state services sector commission, allowing them with a control over their hiring and a whole range of policies, which is what was embedded in the State Sector Act, did create that environment where there was, as Jim was just saying, the idea of a silo and competing. And I know in this town, when you look at trying to hire someone within the state sector, some of your biggest competitors are other state agencies, that you lack that control. And in fact, you're actually trying to hire someone from another agency rather than that opportunity of cooperating and having lost a sort of that sense of that there is a New Zealand public service rather than a bunch of different state agencies. And I think that's probably been what we've struggled with over the last 25 years, and we've still got some way in which we need to try and bring back if we want to have a public service, that we need to try and look at what are the mechanisms in order to make whether the vision that you had, Stan, with the Senior Executive Service, or the question that we've got is how do we make that State Services Commission, a central body like that, actually step up and take ownership and responsibility. I mean, those are the challenges that really the future have got. Have you got any concepts on how we might achieve that?
Well, if you wanted to pursue that line, it would require a fair degree of political will. And one of the things is that in the laying out of the conditions of employment for the State Services Commission would be requirements such as those that you described. The job descriptions are all tailored by ministers individually. They come up one by one. As the jobs are advertised, the job description goes to the ministers. The ministers tweak them, and this has been going on for 30 years probably. And if you want to change the nature of the top beast, you modify the description of the candidate that you require.
Microphone, because we're recording.
Yeah, sorry. There's a couple of points I do want to make, and I think one of the things that a lot of people, that I think Stan and Geoffrey have said, but a lot of people have missed, is that there's ministerial decisions involved in a lot of this, and there's some of you who have heard my views on how we, in all governments, have had a range of ministers, and there have been those that have, both in their effectiveness and their ability, helped to make up the average with the good ones. And there's been tremendous damage done, I think, and partly from having too many ministers within governments. I think the other point that I just want to make about the SES, I was the minister in the end who took it out. And I took it out because it wasn't working after. It was my fault, Stan. It was my fault. After a couple of years of trying to make it work and basically having an ineffectual SSC and the chief executives effectively on strike, and we got to the point of either having to write it into their contracts or that they would release a certain number of people at a certain level for a certain amount of time, and we got to the point that the way the system was working then was it just wasn't worth that. I think we're probably wrong.
Can I just pick up one point that Trevor made? It's not the feasibility of taking out the SES. It's the number of ministers, and I've got a bit of a monitor. I've had it for a long, long time. When we took put the trading activities of departments into SOEs, a huge volume of the day-to-day business of cabinet ministers disappeared. All of that commercial stuff, which they weren't generally very good at anyway, had gone across to SOEs. Why maintain the size of the ministry? Now, it's kept high for political reasons. It was done in our government and it's done in succeeding governments. The bigger your ministry, the more votes you've got, vis-a-vis your caucus. And that's why a succession of prime ministers have maintained executives that are, in my view, excessively large. Now, you look at the costs involved, an average backbench member today of all the support services and air travel and so on is probably 250 to 300,000 per head. If you look at the average minister today, they're probably $2 million per head. By the time you pay the space, the support staff, they've all got too many staff, but that's if you want to have for 30 years. When I got a whole heap of extra stuff and David Loney sat Preble, Geoffrey used to run the allocation of resources, and he said to me, Stan, I've had huge burden, and I point out to you, I had Labour, State Services, Immigration, Railways, SOEs, and Deputy Minister of Finance. He said, any staff you need, you can have. And I asked for one additional media officer.
That wasn't the way your colleagues behaved.
No, I tried to impose that discipline on myself, and I ran a non-party political office. Everybody was appointed there on merit or whatever, but that was unusual too. So I concede that I have certain personal peculiarities, one of which is a view on the size of the executive. It's too big, it's too expensive, and under MMP we want to favour another few votes, so your minister's out of cabinet, your minister's in cabinet, your associate's in cabinet. It's a very expensive beast.
Well, it goes back to Jeremy Bentham's wonderful little pamphlet about placemen. Government is about placemen. Everyone who gets elected as an MP wants to have some role in the executive. They want to be important. They want to make decisions. And they get very upset when they don't get into cabinet. And so in order to silence them, they have made something outside cabinet. I've seen that happen time and again. I will name no names. But it is quite true that the political imperatives to have a large cabinet run one way, and the sensible decision to have a rational allocation of resources runs another way, and the politics always wins. And that's very sad. And I hope a Royal Commission could say something pretty severe about that. But whether anyone will take any notice is another question.
Indeed. All right. Thank you.
I think the current Act and indeed the original Act provides for the Commission to delegate responsibility to chief executives to bargain conditions of employment. And I wonder whether that we've certainly considered why is that delegation there. Is there a place for the Commission to have more of a workforce strategy across the public service? But in practice there's been no suggestion that I've been aware of, apart from in our minds, that delegation may not be given. I just wondered whether in the design of it was ever envisaged that the delegation it may be given and it may be taken back by the Commission, and for what purpose that was envisaged.
I don't recall why that was there. I do recall at the time of the coming into being of the new regime, with authority going to the CEOs, that a document was produced by the Commission, which I had to sign off, which was the sort of template. And I've been reading the history, finished it, very good. Mary Ann O'Connor's history of the piece. Well, it's a series of interviews, and in there's a reference to the PSA working with the Commission on that template for the coming into being of the new arrangements. Now, the Commission certainly did that to give guidance to the CEO. Now, I'm not saying that the draft legislation had envisaged that. I don't think so. And I don't really recall why that was there.
I think...
Do you remember that, Geoffrey?
There was, in the previous law, a lot of difficulty about some powers not being delegated and not being able to be delegated, and I think it was a response to that.
I mean, the Commission for used for a lot of investigation and inquiries in our time and subsequently. I always wanted the Commission to have a rubber on the road. I mean, when Don Hunn was the chair, he came to me and doing a review, and I said to him, look, I want to see some really fine minds attached to the State Services Commission. And he went off and got 4 or 5 assistant commissioners at that time, very smart people, who I thought were going to give a bit more intellectual run to the Commission. Still have that view. Horrified to read in your splendid publication that only with the change of government to the Clark government that you actually met Winteringham, the chair of the Commissioner. I'm astounded. So, I mean, I would have thought you'd have been along every 2 or 3 months having a cup of coffee and a chat on things. The fact that you hadn't been in years, just I was just gobsmacked.
Indeed. Now, no, we've got a question here, actually first, and then at the back. Yes, please.
I just wanted to ask a question around your comment around harmonisation of the industrial relations framework in the public and private sphere, and whether you both think that's still appropriate. And secondly, what you think the appropriate distance between ministers and industrial relation decisions in the public sector is, including around the appointment of chief executives in a modern public service?
Interesting question. Stanley?
There's similar components. At CEO appointments, the ministers are consulted on the panel to meet with the commissioner to do the interviewing. And during the regime which ended 4 years ago, prior to that, I was on a number of such panels for recommendation. I never went back to the minister of that the ultimate appointment was going to be made, to be reported to. I just came in, and only on one occasion was I actually phoned my minister, to my considerable shock. But I always would regard myself as independent, making a judgment on the strengths and qualities. And the description, which a cluster of ministers have said were relevant to the job for the future. Public-private sector industrial harmonisation was done at the time when the private sector was quite strong. Well,
in part,
it had a lot of industrial activity. And I was suspicious that when voluntary unionism came back, as inevitably it was going to do, just what effect it would have on the structure of the private sector. Ken Douglas talked to Geoffrey and I one day, maybe even a cabinet committee, but anyway, and was lamenting the fact that penetration, participation, whatever you call it, was 48%. And we were worried about that. Geoffrey and I shared a concern with you. Down to 48, we said. And partly that was the nature of the workforce, more contracting jobs. I was worried. 48%. Private sector now 9, is it? Perhaps. The whole shape is so different. The trade union movement, predominantly now, is the public sector. It's the PSA, it's the nurses, it's the PBTA, it's the NZDI. Okay, there are pockets in the private sector, and the wharf and the engineers unions are very good users, but the actual number of industrialised people is very low. The Contract Employment Act was a vicious act that cut across clerical workers, shop employees, overtime for Saturday afternoon, all those sorts of things. It was the most vulnerable that we had. And it's happening again. There's legislation in the Parliament which have another go to hit the most vulnerable. I just think that's appalling. Now, how to get it back, I don't know. Some of the stuff is incapable of being turned back, I suspect, and I don't think there's a political will to do it.
I really have nothing to offer about how one sets the salaries, because it's not an area that I've ever studied. All I can remember is that the Cabinet used to get very upset with teachers who didn't seem to have they wouldn't keep to their word. I remember the ministers who were involved in this saying, and the blue collar unions always kept to their word, even though it would be very unpleasant to you. The way in which ministers, I don't think, should be involved in wage negotiations. I do think ministers have to set the financial parameters within which they operate. But you cannot really expect ministers to negotiate wages. I just don't think it's going to work.
I just wanted to raise another point about the ministerial relationship with public servants. One aspect of that, which I don't think has been mentioned, is that they were set up to be purchasing outputs from their agencies, their ministries or whatever.
And that seems to me to be a fairly fundamental thing. It may sound like just a way of expression, but in fact what it says is that public servants really no longer are public servants but ministerial servants, and that they at all times can feel that if their advice is not wanted, the minister can just purchase that advice from wherever else. So it's not a matter of contestability of advice, it's a contestability of the source of that advice. And it quite fundamentally, I think, changes that relationship, so that you have these people who are servants of the minister rather than servants of the public. And they become much more engaged in political risk management rather than in providing the advice that they think is the best advice for the purpose. I'm not just saying this from a matter of theory, because I've been in a governance role in quite a large Crown entity where this was played out repeatedly, and even to the extent that I saw a chief executive resign because the relationship with the minister was obviously not going to work. Now, to me, this has become very serious. And I've seen it from a number of angles, from the inside and the outside, of public servants more concerned about political risk management than about the need for sound advice. And it's not because they're not professional or anything, that's the rules that are set up.
Geoffrey?
Well,
Sam?
I was the president of the Law Commission for 5 years, and I used to have big arguments with the Audit Office, who required me to file all sorts of documents like statements of intent saying what I would do and what I wouldn't do, and I took no notice of them at all. And I simply said to them, look, they said, how can you tell when you're doing a good job? I said, well, the Parliament's passed so many of our bills. Do you apply this test to them? I mean, what do you measure the parliamentary output in the same way? Well, of course, there's no answer to that. There are serious methodological difficulties with the point that you're making, in the sense that what is an output and how does one measure it? And I do think that some of that stuff needs to be revised, because when the rubber hits the road, at least in a Crown entity, and the whole Crown entity's governance is a whole other area that we haven't discussed, but it's a wonderfully rich area. They were all brought together and put in one place by Simon Upton, and the Crown Entities Act was passed, and it does put more system in it than was there before. But for all of that, I do think that there are some serious weaknesses in the methodology by which you go about trying to evaluate what has been done. So I'm in your camp to quite a large degree. But whether or not that drives the incentives, I'm far from certain.
Stan?
I think there was, within your question, that the purchase at a fixed price from the chief executive had within it some dangers that occurred after our departure from office. I had the feeling that Bert, having found that it was possible to try and screw more activity out of the agency for a fixed sum of money, kept driving at that and drove the money down and down. So, look, there's a sort of a hierarchy of things that go wrong when there's money in short. Staff travel gets cut first, then the staff training goes, then your policy functions start to wither because you don't notice that too quickly. And so, my view is that his excessive application of that regime to try and conserve funds within government departments inflicted a lot of damage on the core public service.
Can I ask a question of the audience?
Absolutely, yes.
I would like to know how many in this audience think that the New Zealand Public Service is in good shape. Please raise your hand.
What are the options? What are the options, Geoffrey?
No, I mean...
Good, middling, bad...
Does it need any attention or doesn't it? Is it in a satisfactory condition? No.
If better than serious.
Better than serious. All right, so it's not terminal, but certainly...
If Geoffrey's recommendation to set up a royal commission to be done. And I personally am not sure. But if it was, it would require very careful consideration and a great deal of debate, and there's a great deal of time involved in such a process.
Indeed. Setting
it up, terms of reference, composition and so on. Now, it may be that he's right, but it needs drive from the likes of the PSA, if it were the PSA, that was a sensible thing for ministers to pick up and endorse and drive. It's potentially risky, but it's an interesting suggestion.
Now, look, Trevor, just very brief. And
one response to Geoffrey and say that while a public service as a whole is not in good shape, there are still an enormous number of individuals who are working really well, unfortunately, within departments with no sense of a coherent public service.
Well, I think we should call this to a halt at this point. We've had a wonderful set of presentations, a really good interaction in terms of questions and discussion, lots of unresolved issues, particularly in terms of the way forward, but lots of issues to continue to wrestle with. And so thank you very much, everyone, for coming. And if we could just show our appreciation to Geoffrey and Stan.